Hi, I'm Dan Kuperstein, and welcome to this episode of Compliance Minute. On October 7th, 2015, the Protecting Affordable Coverage for Employees Act, or the PACE Act, was signed into law. The new law maintains the definition of small employer under the ACA as those employers with 50 or fewer employees. Why was this so important? Well, to provide a little background, prior to the law becoming effective, the ACA defined small businesses as having up to 50 employees, while employers with between 51 and 100 employees were considered large employers. Under the ACA, the definition of small employer was scheduled to increase to 100 on January 1, 2016. This had an impact on insurance costs because the ACA's small group market rules are very different and have more difficult requirements than the ACA's large group market rules. The PACE Act, which had bipartisan support and 235 co-sponsors, keeps the small business definition at a maximum of 50 employees, but allows states to extend the definition of small employer to include those with between 51 and 100 employees. In other words, unless a state decides to expand its definition of small employer, there should be no required adherence to small group market rules for groups with between 51 and 100. The new law was drafted in order to prevent the premium increases and to avoid the disruptions to health plans that businesses with between 51 and 100 employees were inevitably going to face beginning on January 1 of 2016. This is a significant change. As we mentioned earlier, the rules are very different for the small group market. Insurers for small employers are required to satisfy very different regulatory hurdles under the ACA than insurers for large employers, and this can lead to high costs when a group has to transition from the large group market to the small group market. For example, insurers covering small employers must cover 10 essential health benefits and can only offer plans that fit into ACA-specified actuarial value levels, defined as either platinum, gold, silver, or bronze plans. Further, small employer group plans must participate in the risk adjustment program and are part of a single risk pool for setting premiums. Finally, insurers for small groups can only consider age, geographic location, family composition, and tobacco use in setting rates for small groups, whereas insurers for large group plans are not subject to these restrictions. While this law came as a big relief to employers, several states still have laws in their books that will increase the definition of small group employer to 100 or less on January 1 of 2016. Accordingly, if your organization employs 100 workers or less, then you need to understand, and very soon, where your state stands with respect to the PACE Act. For more information on this and other topics, please visit our Knowledge Center at corpsyn.com. Thank you.